Hello and welcome to episode 27 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh Dehaas, counsel with the Canadian Constitution Foundation.
And I'm Joanna Baron, Executive Director of the Canadian Constitution Foundation, and Christine is away this week.
In today's episode, we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land.
But first, we've decided to do something a little bit different this week and focus our entire news segments on doing a deep dive into the Online Harms Act that was tabled in the legislature this week. This is a file that obviously we've been watching for a long time. This is the latest iteration. It was previously proposed and died on the order paper in 2021. And free expression is probably the most important issue that we work on. So we have a lot to say about this bill, and there's a lot in this bill. So Josh, obviously, we have a lot to unpack. Why don't we begin? Why don't you take us through a little bit of background for those who haven't been keeping track of the various internet and media regulation bills that the federal government has introduced. And then we'll get into the nitty-gritty details of this really quite disturbing for people who are proponents of free expression like ourselves, bill.
Yeah, so I'll give that background as quickly as I can so people know what we're talking about. So this is Bill C-63, which is a beefed up version of the Online Harms Act that was called Bill C-36, which is the one that died on the order paper, as you mentioned. And this is one of three big internet regulation bills that we've been worried about from a free speech perspective. The first one passed last April, and that was the Online Streaming Act, which puts services like Netflix, Spotify, YouTube under CRTC control. And the goal is to make them play certain kinds of content, not just CanCon, but also things like Indigenous content. And this is a free speech concern, at least to me, because it means the government is now deciding what people are allowed to watch or listen to on Spotify, Netflix, YouTube, that sort of thing. So that's already law. And the second bill was the Online News Act, and this received royal assent last June. This is the one that caused news to disappear from your Facebook and your Instagram feed because it requires big online services to pay when people post links to news stories, pay the CBC or the Toronto Star or whatever for the privilege of those links having been posted. And, this was obviously a bill that backfired in a big way since only Google was really willing to play ball. And it was a free expression concern, not just because it meant government was licensing news, deciding who counts as a journalist that should get money from Google or Facebook, but also, because it caused news to disappear. And so this third bill, this is the one that was tabled this week, and it's the one that we probably had the biggest concerns about because it has the potential to outlaw and chill a really wide range of speech. And we weren't really sure if the Liberals were serious about going this far. We talked about it on the podcast last week about what might or might not be in it. I had sort of thought that it was a pre-election tactic from the last election and that they wouldn't bring back such extreme restrictions on free speech, but I was wrong. So Christine, who's away this week, she won that one because she was pretty sure it would be as bad as it turned out to be. The bill does a bunch of things. So it creates a new Digital Safety Commission, which is like a whole new extra CRTC that will exist to browbeat social media companies into removing what the bill defines as harmful content. We'll get into what that means. And it creates a new criminal code hate crime offense that has a life sentence and applies to basically every act. It's extremely broad. It ups the penalties for hate crimes. It allows judges to impose peace bonds on people who might commit hate speech crimes in the future. It requires immediate takedown of images that sexually victimize children. And most importantly, the biggest part of it is it empowers the Canadian Human Rights Commission to fine people for discriminatory speech. So tons to unpack here, lots of different parts. Joanna, why don't we start off with what I see as the scariest part of this bill, which is giving the Human Rights Commission the mandate to police online speech again.
Yeah, so in our group chat about this, I described this off the cuff. I didn't think it was very funny, but this is just the analogy that came to mind. That it was like a muffin that didn't turn out well, and you had it sort of socked in the back of your freezer, and the government has decided to go back to the back of the freezer to that muffin that's been there for over 10 years, and everybody agreed was bad to begin with, and just toss it out and serve it up again because I guess the basic infrastructure or the basic idea or the bureaucracy, most likely the bureaucracy was aware of this possible thing. It's like, you want to get tougher on online speech? Let's bring back Section 13 of the Canadian Human Rights Act. So this is a civil remedy for so-called instances of online hate speech. And of course, this was widely criticized for reasons that we'll get into under the Harper government, and it was ultimately repealed by a private member's bill about 10 years ago. But anyways, it's back. So by it, I mean a new process for individuals and groups to bring complaints to the Canadian Human Rights Commission that online speech directed by them, or even actually just online speech that they witness, is discriminatory. This tribunal is empowered with the ability to order fines up to $50,000 that just gets paid into the Receiver General of Canada. Thank you very much. And then $20,000, lesser amount, but still generous, for complainants who in some cases could be anonymous. So this means you could have a complaint brought against you that you were doing an online hate speech act and not even know who had brought the complaint. And then, of course, because we're talking about a civil process, as opposed to a criminal process, the findings would be based on the much less stringent balance of probability standard rather than the more rigorous criminal standard of proof beyond a reasonable doubt, which basically means that the threshold for these kind of complaints has been lowered, and we could expect that there will be many more people accused of and facing these types of complaints in the future. And to accommodate that, you do see a provision that the Canadian Human Rights Tribunal is now set to bloat out to up to 20 members to hear these complaints. And of course, these are all government-appointed bureaucrats that are going to be deciding on this and deciding whether or not to impose these stiff fines. And so, as I mentioned at the top, this was the law until 2013, when it was repealed by a private member's bill under the Harper government, because it was widely seen as a scourge and a huge problem for free expression. And so, of course, the world was a little different at this time. So the sort of most prominent case of a complaint of this sort was in 2006. So Maclean's magazine, remember, that used to be an important, thinking person's magazine in Canada. Didn't you work for Maclean's, Josh?
Yeah, I did. It was after this period, but it was it was a big deal back then. Everybody paid attention to our cover stories. We had a huge subscribership, and it was a different time. Now they just write about fancy cottages, and I think they have about 3 staff. But anyway,
yeah, exactly. It used to be like the Atlantic of Canada, and anyways, so they published a cover story by Mark Steyn, the famous pugilist, entitled "The Future Belongs to Islam." And the theory of this piece by Steyn was that liberal democracies with low birth rates and weak national identities would be overwhelmed by the much more fast-growing Muslim demographic that was more oriented towards Sharia law and theocratic rule than democracy. Around the same time, Ezra Levant, another S-disturber, published controversial cartoons depicting Prophet Muhammad. And so human rights complaints alleging discrimination were brought, including a Section 13(1) complaint against Steyn. These were dismissed, but the notion that the state could just haul journalists before tribunals for controversial speech, where they faced these extremely punitive fines, was widely condemned. Even the Toronto Star was opposed. And so this is kind of the nub of the issue, is where do we draw the line between controversial, edgy, uncomfortable ideas and so-called hate speech? Josh, you're going to write about this, I think, in the next week. And you have a great tweet storm about this, is that there is no clear objective line. Like, we do this for a living and we couldn't tell you, like, there's no objective formula. There's no way that you can sort of put your finger on when the line is crossed. And because of that, that creates this huge specter, this chill effect, that huge amounts of protected speech that maybe is uncomfortable or controversial, but has, the notion is it has some worth in the public marketplace of ideas, because how we sharpen our tools and figure out what we believe in is by being exposed to all kinds of ideas that we don't agree with. So this came before the Supreme Court of Canada. The constitutionality of this Section 13 civil remedy for hate speech in the case of Taylor. Josh, I don't know if you want to jump in and talk about this Supreme Court case and how and the background about it and how useful or not useful it is in actually pinning down what hate speech is.
Yeah, so Taylor is a fascinating case. So Taylor, he contravened a provision that was like Section 13, and he did it by distributing cards that invited people to call a number where they would hear recorded messages that denigrated Jews. And, I guess this was how you had to do it back before the internet. You couldn't just like tweet out neo-Nazi things. You had to actually like spread cards throughout the community that people would call and then, hear, I don't know, whatever conspiracy theory. So anyway, the tribunal ordered that he stop, and he didn't comply. So a court fined him $5,000 and ordered a 1-year prison sentence, which was suspended on the condition that he comply. And he still didn't stop. So he was imprisoned. And the whole time this is working its way through the courts, it's being covered in the media, and he's getting all of this attention that he wouldn't otherwise have got. But anyway, he took it all the way to the Supreme Court and he lost. And the whole debate at the Supreme Court really was about this subjectivity question about, can you define what is hate that's so extreme that it's going to cause harm worthy of limiting in a free and democratic society, which are the only limits that are allowed on expression under the Charter of Rights and Freedoms. And Chief Justice Dixon won this argument, and he basically said, the phrase hatred or contempt refers only to, quote, unusually strong and deep felt emotions of detestation, calumny, and vilification. And so he saw little danger that subjective opinion as to offensiveness will supplant the proper meaning of the section. And Justice Beverly McLaughlin, who went on to become the Chief Justice, she made the argument that we at the CCF make, which is that, you can't really draw a line, and you're going to chill a huge amount of speech by even just trying to draw a line. So we should just allow people to say what they want to say and not, criminalize that or bring people to human rights tribunals. So I like this quote. She wrote, "Novelists may steer clear of controversial characterizations of ethnic characteristics. Scientists may well think twice before researching and publishing results of research. Given the serious consequences of criminal prosecution, it is not entirely speculative to suppose that even political debate on crucial issues such as immigration, educational language rights, foreign ownership, and trade may be tempered. These matters go to the heart of the traditional justifications for freedom of expression." And that's the point here. Like, we need to be able to talk about the most controversial things without fear of censorship. And something like Section 13 or criminal hate speech provisions don't allow us to do that. And so this came up again in the Watcott case, which the CCF intervened in. And this was an appeal of a Saskatchewan Human Rights Commission provision involving a Saskatchewan Human Rights Commission provision similar to Section 13, which was used to punish this Christian man named Bill Watcott, who had been handing out pamphlets that said, "Keep homosexuality out of Saskatoon's public schools," and had all kinds of nasty things in there about gay people. And here, the Supreme Court, with Justice Rothstein writing the opinion, revisited this question of the subjectivity, and he sort of reined it in and said, Dixon was wrong. You can't include calumny. That doesn't count as hate speech. But he said the most extreme manifestations of the emotion captured by the words detestation and vilification can be outlawed as hate speech. And he said this doesn't include speech that, while repugnant and offensive, does not incite the level of abhorrence, delegitimization, and rejection that risks causing discrimination or other harmful effects. He also found that certain types of speech, like offensive speech or speech that merely ridicules, that's fine, that's not hateful. But again, you read that definition. I've read that definition a bunch of times. I'm sure you have too, Joanna, and try to parse out, okay, well, what is speech that ridicules versus speech that vilifies? Ridicules is apparently fine and legal and protected, but vilifies is not. And it's just really impossible to know where the line is. And so what's even more worrisome is some of the examples of what Justice Rothstein told us in Walcott to look for in order to know where that line is and whether speech falls over that line into something that is hate speech. He said you need to look for the, quote, hallmarks of hatred. And these are, indicators of possible hate speech. But the problem with these is they include a lot of things that are, again, quite subjective and things that we should probably be allowed to say. And I'll just go through some of the examples. So these were this is the tweet storm that you referred to, Joanna. So one hallmark of hatred is blaming a group's members for the current problems in society, alleging that they're a powerful menace. So, the first the first thing that jumps to mind is all of the EDI training that I've had over and over again at university and in various jobs over the past few years, where the argument is basically that white people and also white men in particular have all of the power, and that a lot of the problems in society, especially with inequality, are the problems of white men being too dominant and trying to hold on to power for themselves. And I don't like that. I don't like that particular argument. But there is.
Because you're a powerful menace, Josh.
I know. Well, I guess I am now.
The menace of Leslieville.
But anyway, that's. I don't think most people would see that as hate speech, but it's apparently a hallmark of hatred. Another one is, this idea of a group carrying out secret conspiracies to gain global control. Joanna, I think you hear that one as a.
This is me. This is directed at me and my people. Yeah, I just this week I wrote about it in the Hub. There was somebody on Twitter that was calling me a Caucasoidic Jew running a Jew charity, which I guess I am a silver Jew. I do have blonde hair, but no, the CCF has no affiliation with any religion. But yes, that is lock, stock, and barrel, the classic narrative about Jewish people. But we've talked about before, the same with even Holocaust deniers. When you criminalize these things, first of all, you give them a weird type of purchase amongst the nitwits that are inclined to believe this stuff in the first place, by driving it underground. And you give these people a platform like Ernst Zundel, where, you had Holocaust survivors on the stand being cross-examined by Zundel's defense counsel. So it just gives them more of a platform and, in a sense, legitimizes crackpot theories. There should be no problem in society with saying that people that peddle this stuff should, be delegitimized. You don't have to frequent their businesses. You don't have to hire them. But when we're talking about criminal law, we really want something that is objective, clearly defined, and that has identifiable harms, not just this amorphous, which I think is really driving a lot of the overall impulse, getting back to this online harms bill. It's a lot of virtue signaling. It's a lot of symbolic politics of saying, we strongly denounce people doing hate things. But when you look at the spill-on effect, or as we like to talk about, the chill effect, it has a much wider catchment.
Yeah, totally agree. So I just want to go through a few more of these, just because they're kind of fun. So one of them, another hallmark of hatred is plotting to destroy Western civilization. And, this gets thrown around a lot against various groups, but can you not imagine a scenario where there is like some country out there, like some foreign country that really does want to destroy Western civilization, and if that comes up, should we not be allowed to say that?
Yeah, I mean, you should read Hamas's charter. It's pretty clear that's what they want to do.
Right. Another one is delegitimizing the targeted group by suggesting its members are illegal or unlawful. And, are we going to see complaints based on, the no one is illegal type argument, right? Like we have certain groups in Canada right now, like this was a news story in like all of the major newspapers. Um, there's been a huge uptick in Mexican nationals that are like falsely claiming asylum, and there's a conversation about whether Canada should impose visas to prevent that. But if I suggest that this group is illegal or unlawful, am I going to face a human rights complaint? I mean, probably, and yeah, maybe it'll be tossed out, but I would have to defend that. I would have to spend time and money doing that. And well, I wouldn't hire a lawyer, but a lot of people would have to hire a lawyer to just defend that. And another one here that jumps out is exposure to hatred can result from expression that equates a targeted group with groups traditionally reviled in society, such as child abusers or pedophiles. And there's a lot of people out there right now that use the G word, groomers. And, I find that can be quite offensive because it's sort of equating people that believe in gender transition with people that are pedophiles. But the word groomers also means a lot of different things to different people. And then the last one is describing a group's members as animals or as subhuman or horrible creatures who ought not be allowed to live, incognizant primates, genetically inferior or lesser beasts. And, I was thinking about this. Hamas is a great example. Like I'm pretty sure they want to kill me and all the other gays. So I can't call them animals or lesser beasts or something like that. Like, come on. This is the problem, though. Joanna, you had an example too of TERFs.
Yeah, well, this just goes to, and I was thinking about this because a friend got really offended by something that that Christine said at one of our book events, where she was talking about how abhorrent it was that pro-Palestinian protesters were targeting a Jewish neighborhood. And this friend of mine was really offended, and it just brought back to me how a lot of the context of how inflammatory a comment will be kind of relies on your in-group or your out-group, like your affiliation. And TERFs is a good example of this. So TERFs, and I remember about 5 years ago, I was at a Running Need Society event with John Kay, and I hadn't heard this term, and he was like, "Oh, that's good. It means you're not on Twitter a lot." But this was like early TERF days. So it means trans exclusionary radical feminists. So these tend to be the women are women and trans women are trans women, not biological women. So in certain groups, like the Quillette John Kay circles, being called a TERF is like a badge of honor. Like, yes, I stand up for, natural biological women's rights to, compete in sports without biological, trans women who have different testosterone capacities. But in other circles, like, just as J.K. Rowling, that is a direct incitement and vilification and dog whistle for certain types of online mobs to come after you. You can listen to the witch trials of J.K. Rowling to hear exactly just how that can go. So all of this I just point to, and I don't have a stake in the ground on either side of this particular debate, but it really just shows how the schisms really can determine how context determines the particular valence of calling someone something. So there's not just like an objective way of singling out when speech crosses the threshold of inspiring intense vilification or detestation. And then the concern, because all of this is being implemented by the government, is that it will be what the government agrees with and what the government finds hateful. And that's not the government's role.
Yeah, that's right. So, and you can think about who the government might choose to appoint to these positions, and then it's up to them. It's their particular taste whether you've crossed the line or not, and the consequences are severe. Like even if it's not $50,000 fine that you get, or even if you don't end up having to pay $20,000 to your accuser, just the fact of having to face one of these complaints could potentially destroy your career, and it's going to cause you a lot of stress. And just before we move on from this whole idea of the subjectivity of hate speech, I just wanted to mention I saw this video recently from FIRE, the Foundation for Individual Rights in and Expression, used to be education. And they were talking about hate speech in the UN Declaration of Human Rights. And so that is the international human rights document that was created after the Second World War, after the horrors of, the Nazi genocide. And there was a big debate then about whether to include hate speech. And Eleanor Roosevelt for the United States, she was very opposed to including hate speech because she saw that it would be abused by governments to, shut down speech that they don't like, shut down the speech of their opposition. And she said, quote, any criticism of public or religious authorities might all too easily be described as incitement to hatred. In other words, hate speech is often just sort of a cloak for sort of blasphemy laws, and it's religious leaders and also authoritarian politicians who are often most in favor of hate speech because they can use it to shut down their critics. And Roosevelt won that time around, but the countries that were in favor were Stalin's Soviet Union. So Stalin wanted hate speech provisions. South Africa, which had all kinds of laws to protect its apartheid system, and banned racial hatred because they didn't want people to criticize the white minority that was ruling over the whole country, and Saudi Arabia, which is very concerned about blasphemy. So you had the U.S. and some Anglo countries opposed to hate speech, and it was Stalin's Russia, apartheid South Africa, and Saudi Arabia that were in favor. So that should tell you all you need to know about that. Okay, enough about that part because there's so much more to the bill to talk about. So another part that is really scary to us is that the bill would increase the maximum sentence for advocating genocide from 5 years in prison to life in prison. And advocating genocide is bad. You should not do it. It's a very bad thing to do, but life in prison for words. And Andrew Coyne wrote a column on this bill, and he's in favor of some parts of it, but he thought this was especially crazy. He said, quote, at a time when the air is thick with accusations that one side or the other of a current conflict is promoting genocide, this seems almost reckless. Is it not obvious how this could be abused?
Yeah, so I want to know, the obvious case is calling for from the river to the sea, which has widely been interpreted as ethnically cleansing the Holy Land of Jews. Is that advocating genocide? Because it's certainly been interpreted as such.
Yeah, exactly. Scary stuff.
Yeah.
So what else is it?
I mean, I don't like that, but I don't want those people to go to prison. But while we're talking about offenses that now have a potential term of life imprisonment, maybe we should talk about the brand new criminal code offense. So a new freestanding offense has been added to the criminal code. I'm just trying to look for the section. Yeah, so section 320, it's any offense motivated by hatred could now be liable for a term of life imprisonment. So kind of what this does is normally if a prosecutor can prove that an offense like an aggravated assault or a sexual assault or damage to property is motivated by hatred, the sentencing judge can consider that as an aggravating factor and ratchet up the sentence. Now, at the press conference, Minister Varani said that now this is a standalone offense that will focus police and prosecutors on charging hate crimes at the front end rather than having it at the back end. To me, this suggests two things. First, as we mentioned before, it's a lot of virtue signaling politics. We want to show that we're being super vigilant. We're against bad people, but it also is giving a pretty explicit signal to cops and crowns that we want you to track down and charge more of these crimes. And then just again, Andrew Coyne also in his column talked about this is a freestanding offense that could apply to any offense that is an act of parliament. So you could think about a fairly benign offense, like, I don't know, theft under $100. Everybody shoplifts from the drugstore now. Or sorry, we're not in San Francisco, but something benign like that, that if it was proven that, you were shoplifting from a particular ethnic group's convenience store and your offense was motivated by hatred, maybe this is a little bit impractical, but it's possible on the text that you could be liable of a crime with a maximum term of life imprisonment. Like, it's just the absurdities. And I don't think any of this has been communicated well, how the government is actually intending these offenses to be used.
Yeah. So another one. Speaking of not knowing how this will be used, but reading it, just reading it suggests that it could be used for some really terrible things. Is this whole section of prior restraints on people who believe on reasonable grounds? Prior restraints on people who judges believe on reasonable grounds could commit speech crimes in the future. And so this is called the fear of hate propaganda offense, or hate crime. And basically, we're trying to envision how this would work. So maybe you want to have like a rally, and they're probably picturing something like a neo-Nazi rally, and people say, oh, this is being advertised, and then I don't want this rally to happen. And you can go to a judge, and the judge will say, Mr. Taylor, like, if you hold this rally, we're going to put you in jail. And if you sign this recognizance to keep the peace, and you don't hold the rally over the next 12 months, then you won't go to jail. It comes with some severe potential conditions too. So maybe you're not in jail for this potential future speech crime, but you can be forced to give up a bodily sample. You can be forced to refrain from drugs and alcohol, give up your firearms, even wear an ankle bracelet. And a friend of mine pointed out that there's a section here that also says, if the provincial court judge adds a condition described in subsection 7, the judge shall specify how the things referred to in that subsection that are in the defendant's possession shall be surrendered, disposed of, detained, stored, or dealt with, and how the authorizations, licenses, and registration certificates that are dealt with by the defendant shall be surrendered. So that means that, they can take your firearms away if you're forced into one of these recognizances. And I think the case they're picturing is probably something like a neo-Nazi rally, but what if it's like a parental rights rally, right? Like, I think we could easily see someone that's opposed to what many people call gender ideology in schools, if they are a little bit too cutting in their criticism of school policies, might be forced into a recognizance and basically have their life ruined as a result.
So why don't we take a break, and then when we come back, we'll talk about how this bill proposes to treat platforms themselves.
Hi, I'm Russell from the CCF. In case you haven't already, make sure to subscribe to our email newsletter, The Freedom Update, to get updates from me every week about our ongoing work and the legal stories in Canada that keep us interested. It's one of the best ways to stay up to date. Subscribe at theccf.ca/freedomupdate.
Okay, so the last sort of big chunk of how this bill operates that we wanted to talk about is what is called jawboning. So it's ways that the government can exert control and to some extent delegate to social media platforms like X and Facebook, and pressure them to impose their own policies, but within the strictures of the government's oversight and regulation. So here, the bill is going to require social media companies to adhere to a quote unquote duty to act responsibly, which includes minimizing the risk that users of the service will be exposed to harmful content. And this will be, of course, overseen by the Digital Safety Commissioner. And there are massive fines that are threatened if the companies are found to not properly mitigate the risk. So the fines are up to $10 million or 6% of global revenues. Of course, whichever is bigger, because the Digital Safety Commissioner has got to get paid. So there are 7 categories of content that are specified in the bill as quote unquote harmful. First is sexually victimizing children, bullying, inducing a child to harm themselves, extremism or terrorism, inciting violence, fomenting hatred, and intimate content posted without consent, aka revenge porn, including deep fakes. Shout out to the Taylor Swift AI deepfake, which I did not see, but I understand I was not allowed to search for it on X a few weeks ago. And content that foments hatred is defined as that which, again, expresses detestation or vilification of an individual on the basis of a prohibited ground of discrimination, and that, given the context in which it's communicated, is likely to foment detestation or vilification. And the bill also specifies that this threshold is not met solely because the speech expresses disdain or dislike or discredits or humiliates or offends. And so one improvement, we say nice things as well as mean things, is that the previous iteration of this bill in 2021 proposed across the board 24-hour takedown requirements. So if platforms didn't effectively take down hate speech or harmful content within 24 hours, they would be liable for these hefty fines. The 24-hour takedown requirement has been tailored down to just the revenge porn and child sexual exploitation material. So I think that's good. I think we should take a zero tolerance approach to that type of content. And it's also categorically different than quote unquote hate speech, right? Like they're out, like something either is depicting sexual exploitation of a child or it's not, as far as I can tell. It's certainly much more black and white than if so-and-so's comment about TERFs amounts to hate speech. So I think it's good that they've tailored that in that way. Nonetheless, with this new requirement to flag harmful content and mitigate the risk to the users, I think it's very likely to say that the platforms will err on the side of content, block large amounts of speech that's close to the legal line. And this will all be enforced by a digital safety commissioner, which again will be run by another government bureaucrat. Michael Geist, who's considered probably the leading expert in this country on this issue, has commented that the digital safety commissioner is being granted a swath of powers that is remarkable: rulings on making content inaccessible, investigation powers, hearings that can be secret, establishing regulations and codes of conduct, and the power to levy penalties. There's an awful lot there, and questions about commission oversight and accountability will be essential. There is also a signal that these companies, as they carry out these policies, don't necessarily have to comply with the charter, which specifies that you have freedom of expression and you are presumed to have free expression. Any infringements on that rights need to be demonstrably justified in a free and democratic society. Instead, the language we see is that the operator, subsection 1, does not require the operator to implement measures that unreasonably or disproportionately limit users' expression, which seems like a very low bar, almost like a reverse onus, I would say. Anything else to say about the platforms, Josh?
Yeah, so I want to get into this idea of the job owning. So, that's basically the idea where, Justin Trudeau or Joe Biden or the Digital Safety Commissioner, who will be appointed by Justin Trudeau and his cabinet, they know that they can't stop something because it would violate the Constitution. So they can't prevent some sort of speech because it's going to violate the free speech protections. But they really also just want that speech to stop. So they sort of shake their big stick and talk really loud about getting rid of that speech. And this bill does encourage that sort of job owning by the Digital Safety Commissioner because, for example, it's going to require annual reporting on speech that is not considered harmful content according to the bill, so not rising to the level of hate speech, but speech that, quote, the operator had reasonable grounds to believe posed a risk of significant psychological or physical harm. So they're basically encouraging X or YouTube or Instagram or whatever to have a process to complain about speech that is not hate speech, but that is still harmful. And, tell us whether you took that down or not. And we want to know how many posts this year that were taken down because there was a risk of psychological harm. So that's legal speech that they're sort of encouraging to also be taken down. And I think that makes this even more overbroad. And another thing, just the last thing I'll point out is the last iteration of this bill had 24-hour takedown requirements for harmful content, including hate speech. And now that just applies to the stuff that is obviously the stuff that should be coming down, which is images of like child exploitation. And that 24-hour takedown requirement is gone, but that doesn't mean that social media companies aren't going to take that down, because the bill still requires a process for, flagging potentially harmful content, and it'll then be up to the social media company to decide whether to take it down, and they have to report on that at the end of the year. So they're not being required to, but they might still do something like a 24-hour takedown policy. So it could end up being almost as bad as it was before. So lots going on in that bill. I know we've talked at length. Are you ready to move on to our bad legal takes, Joanna?
Let's close it out.
All right. So my bad legal take is from Amber Mack, and she is a podcaster, business journalist, and keynote speaker for hire. And she has a huge following on X, and it's probably because she has such strong opinions. And in response to a statement from the Conservatives that says basically that, the current criminal laws on sexually victimizing children should be enforced, and that there should be some new laws around things like deepfakes, but, quote, "We do not believe that the government should be banning opinions that contradict the Prime Minister's. Common sense conservatives will protect our kids and punish criminals instead of creating more bureaucracy and censoring opinions." Now, Joanna, you pointed this out in your column in The Hub, and Christine also sort of anticipated this, that the Liberals would put measures to require takedown of child exploitation images and other really nasty content that nobody wants to see online, like terrorist content, in this bill, so that anyone who opposed the more serious speech restrictions could be accused of supporting child exploitation. And that's obviously what Amber Mack does in this tweet. And it's either stunningly naive and she's just taken the bait, or maybe it's some sort of strategic take. I don't know if she is being maybe paid by the Liberal Party or wants to run for them in the future. It's definitely got that kind of vibe. So Amber Mack tweeted, "So, Canadian parents, just remember this. Pierre Poilievre doesn't want to regulate social media companies to stop the spread of child pornography or self-harm algorithms or pedophile networks, but instead prefers to let those social media companies do what they want in the interest of ... free speech. He's more concerned if your child wants to be called Samantha versus Sam than actually protecting them from predators on the internet. These social media companies are raking in profits while repeatedly getting caught exploiting our kids. These social media companies can afford to put guardrails in place. Our police departments do not have the bandwidth to tackle this out of control digital crisis." And then she says, "A reminder, 79% of sextortion incidents occurred on Instagram." She says Instagram's recommendation algorithms are promoting pedophile networks. I don't know about that. And she says among teens that report suicidal thoughts, 13% of British users traced their desire to kill themselves to Instagram. Like, this is just so over the top. So, Poilievre has committed in his statement to expanding criminal bans on communication without consent. And he also pointed out that sexually victimizing kids online is already illegal. The platforms are already they don't want this content on there. Like, no platform does. They're already taking tons of steps to eliminate that. If you're a social media company and you're trying to sell ads, the last thing you want is any of this type of content that is about victimizing kids. And so, even giving her the benefit of the doubt, maybe she was just watching the media coverage and she really did just buy into the line that the government was trying to sell. I don't know how much media coverage you watched of this, Joanna, but I watched the National on CBC on Sunday, and they had a leaked story from the government about how this would all be about protecting kids, and they interviewed the mother of Amanda Todd, who was a girl who tragically was bullied online and died by suicide. And she was talking about how great this bill would be, and then on Monday, what happened was the press conference announcing this bill didn't happen until 5:15 p.m. and the text was not available until then either. Like, they gave journalists a technical briefing and told them, oh, this is what's going to be in the bill, but they couldn't actually read it until basically you're almost at the supper hour news. And if you're something like the National, you've already had to line up all your people to speak on this bill in order to get your story done by 9 p.m. And so the story that aired on the National really was about how this bill is just all about the child exploitation stuff, and they didn't get into the harms at all. I think there was like one sentence at the very end of the story that was critical, and it was said something like, Pierre Poilievre said last week that he's opposed to censorship. So giving her the benefit of the doubt, maybe she just bought a little bit too much into the spin. But either way, it is a very bad legal take to suggest that just because you don't support a censorship regime that's built into this bill, that you're somehow siding with the child predators. Joanna, let's hear your bad legal take.
Okay, this is sort of misapprehension from the other side. This is from Keaan Bexte, and he tweets, I have been reading about Justin Trudeau's online harms bill all day. People are not grasping the sheer magnitude and malice of his plan. This law will be Trudeau's final blow when it comes to regulating freedom in Canada. Our history will be remembered as before and after the implementation of this draconian act. He intends to suffocate Canadians who oppose his rule. Hong Kong recently passed laws banning speech disallowed by the government, and a generation of young adults fled. I'm in shock, and I'm forced to consider moving the counter signal and my family out of the country. Okay, Keaan, first of all, as you pointed out, Josh, this is like the version of Americans who always say they're going to flee the country if Trump is reelected, and then pretty much none of them do it. So I don't know if you really are going to leave the country because of the online harms bill. But I think Justin Trudeau is somebody who's more incompetent than deliberately malicious and evil. I don't think there's a sheer magnitude and malice of his plan. There is a clarification that content does not reach the threshold of hate speech just because it expresses disdain or dislike. Of course, that doesn't solve the problems of chill that we talked about. It doesn't solve the problems of vagueness, but it does go somewhat to the government's intent. I don't actually think this bill is aimed at silencing political dissent. I think it puts Canada in line with other legislative regimes that we've seen in Europe and Australia, although we'd have critiques of them. And it kind of has walked back some of the worst proposals, like the across-the-board 24-hour takedown requirements. But I think in general, Keaan, my overall take is that the notion that the government has anything like a systematic plan for imposing some type of authoritarian regime is fanciful. So thank you, but try again later. Bad legal take.
All right, so as usual, we hope you'll rate us, review us, and subscribe. And I really do mean to go rate us and review us now, or we will report you to the Digital Safety Commissioner. And just a reminder that you can support our work by subscribing to the Canadian Constitution Foundation's YouTube channel, by following us on Twitter, or by visiting our website, theccf.ca, where you can sign up for our new and improved Freedom Update newsletter from our colleague Russ. The Canadian Constitution Foundation is a nonpartisan legal charity funded by your donations, so please click that donate button on our website if you can. Thanks for listening.